Kanu rush Court of Appeal to stop November 20 judgment. Terrorism law don expire. Charges invalid. Dis na CenokMedia, the channel wey dey report the news and dey make am simple for everybody to understand. We dey thank una when you dey view us. Abeg subscribe if you never do so. Put on your notification bell. E go tell you as we drop update. Like, comment and share the video. Hello my people, how una dey today? Today matter wey we wan gist is serious. E concern Nnamdi Kanu, the leader of the independent people of Biafra wey dem dey call IPOB, and in long-running terrorism trial wey don dey since 2015. Just last week, Federal High Court Abuja under Justice James Omotosho don fix November 20 as the day wey dem go give final judgment for dis matter. But Kanu no just sit down look. No, e don rush Court of Appeal Abuja. Dey try make dem restrain the lower court from giving judgment. Why e do am like dis? Make we break am down slowly. The case against Kanu dey terrorism matter and e don drag on for over 10 years. Kanu don sack im lawyers and decide say im go defend himself. But later, e come claim say no valid charges dey against am because the terrorism law wey dem charge am under don expire. E do one application wey dem dey call no case submission, where e tok say, "Judge, nothing for me to answer here because the law don disappear." But Justice Omotosho dismiss the no case submission and still give Kanu chance to enter in defense. Kanu try beg make judgment adjourn indefinitely last week. Court say no and fix November 20 as the judgment day. Na so Kanu run go Court of Appeal on Wednesday, November 12, dey pray make dem stop the lower court from giving judgment. Inside the affidavit wey Kanu submit, e tok say the terrorism law don dey repealed, so the charges no longer valid. E argue say lower court no consider jurisdictional issues properly. E tok say judge no properly evaluate prosecution witnesses before dismissing no case submission. E complain say im right to call 23 witnesses for defense dey blocked because court say dat one go happen only for final judgment. Kanu tok say if appeal court no grant dis order, e risk being unlawfully convicted and appeal go turn mere academic exercise. E also raise Supreme Court matter. Count 7 of the charges don expire by Supreme Court order, yet lower court dey proceed like say e still dey valid. Kanu tok say denying im motion go shut am out of constitutional right to appeal. Dis one no be small matter. If November 20 judgment land and Kanu win nothing, im appeal go almost dey useless. On the other hand, if Court of Appeal grant am stay, e mean say judgment no fit drop until appeal matter dey resolved. Dis one go set precedent how court go handle cases based on repeal law and how constitutional rights to appeal fit dey fully respected. Many people dey watch dis one closely because e fit shake politics and legal circles for Nigeria. The public dey split in opinion. Some dey reason say Kanu just dey play legal delay tactics. Others dey support am. Dey tok say every citizen get right to full defense and law must dey respected. The matter also bring focus back to Nigerian legal system, where cases fit drag for decades without final resolution. Some analysts believe say Kanu dey try use appeal to buy more time, make judgment no land before appeal go through. Dem dey believe too say e fit set precedent for other high-profile trials where defendants dey argue say charges dey based on repeal laws. Dis one no be just legal strategy, na race against time for justice system integrity. Kanu dey highlight constitutional issues, jurisdiction, rights to call witnesses, and fair trial. Dis matter fit force courts to clarify how repeal laws fit affect ongoing cases. E dey more than Kanu, na test of Nigerian constitutional safeguards. Kanu dey argue say count 7 of charges already dey nullified by Supreme Court, but Federal High Court dey ignore am. e say dis disobedience fit make judgment invalid. E dey challenge how lower courts dey respect apex court rulings. But many Nigerians dey split on Kanu's tactic. Some see am as delay tactic, others dey see am as right to defend self. The story fit stir political debates around IPOB and southeastern separatist issues. Public eye dey closely monitor because outcome fit affect perception of justice and government legitimacy. Appeal court go face pressure to rule quickly because judgment dey set for November 20. If dem delay, e go raise questions about speed and efficiency of Nigerian appellate courts. This one fit become a headline on judiciary efficiency, not just Kanu trial. This Nnamdi Kanu terrorism trial don throw up many oddities. Kanu sacking lawyers and choose to defend himself. This unusual move dey rare for high-profile terrorism cases. E dey challenge the norm. E wan show say individual fit defend rights even under serious charges. Also, e dey bring about the issue of repealed law versus reality. Charges dey based on a law wey officially don repeal, yet court dey proceed. This one na live example of how law fit lag behind courtroom practice. E dey highlight grey areas in Nigerian legal system. Kanu dey claim say e wan call 23 witnesses, but lower court block am until final judgment. This na real-life suspense. What if witnesses go change story? What if evidence dey crucial for outcome? Depending on how appeal court go rule, dem fit become heroes saving justice or villains shutting down appeal rights. Kanu dey fear say once judgment land, appeal go turn mere academic exercise. E go be done deal. Dis ten sion dey real because outcome fit influence future of high-profile trials in Nigeria. Another oddity na say count 7 don already expire by Supreme Court, yet lower court still dey try proceed. Dis one don become clash between apex authority and trial court. Kanu case na microcosm of Nigerian justice perception problem. Public dey observe, dey critique, dey discuss legitimacy. As Court of Appeal dey prepare to hear Kanu motion, ten sion don full everywhere. November 20 dey close, the day wey Federal High Court don fix to deliver final judgment, and Kanu dey fight make everything stop until appeal matter settle. The questions wey everybody dey ask now: the court go grant stay and protect a constitutional right to appeal, or judgment go land and make appeal turn mere academic exercise? This matter not just concern one man or one trial. E dey test integrity of Nigerian justice system, how courts dey respect repealed laws, Supreme Court orders, and the rights of every citizen to fair trial. Nigerians dey watch closely. Public opinion dey split. Political eyes dey sharp, and e sure say whoever handle this matter go leave strong imprint for legal history. So we go continue dey follow am closely, dey give you fresh updates, and as the story dey unfold, remember say every twist fit change outcome, and every decision fit carry lessons for law, justice, and governance in Nigeria.